I said from the start, as soon as they started making these anti-AI cases class action cases, I said who was going to be the one getting all the money. It was going to be lawyers, and it was going to be publishers, and authors were going to get a pittance. Well, I think I've been vindicated here in Bart's v. Anthropic, because here is a complaint that we haven't been able to see, because it's been sealed. This is from Professor Leah Bishop, and we'll get into what exactly she objected about, but this was sealed even though she didn't ask for it to be sealed. Apparently the clerk just sealed it for no reason. Kinda makes you wonder what was going on in the background. Like, who was it that didn't want us to see this? But she moved to unseal it, so we have it now, and one of the publishers has actually responded to it. So we'll see what that jerkwad has to say later on, but first of all, let's hear from Bishop. This case was brought by authors against Anthropic for copying their books without permission. And remember, all the AI stuff, Anthropic won on that. The training is fair use. The whole thing is fair use. It's just the initial downloading from the so-called shadow libraries like LibGen and Polemy, which should be a part of it, because if the rest of it is fair use, it shouldn't matter how you obtained it. That's what was actually said over in Cadre v. Meta. And so just to quickly review what we've already talked about, they were making an interlocutory appeal up to the Ninth Circuit about this question. And it really looked like Anthropic had a good shot of winning, which would have ended the case, ended a lot of the AI cases, because this would have been absolutely fair use from start to finish. So then the plaintiffs settled for $1.5 billion. That sounds like a lot of money, but that's peanuts compared to what they were suing for, which would have been in the hundreds of billions. So of course Anthropic jumped on that. But now everything since then is about who's going to get the money. And Bishop says that money belongs to authors, which makes sense since it was authors who filed this case, right? Nonetheless, before this court is a proposed plan of allocation and distribution that would divert most of the class funds to publishers. What did I tell you, people? Bishop respectfully asks the court to consider three things: how Judge Alsop's views on the fairness of this settlement soured between August and December, whether publishers have any legal right to share in authors' settlement proceeds, and whether authors' interests would benefit from independent representation. In other words, not the ambulance chasers who have been representing them, who apparently have been making some backroom deals with the publishers. Publishers did not file this case because these damages are not theirs to recover. After discovery, they inserted themselves and corrupted the settlement process by entering into an undisclosed fee-sharing arrangement with class counsel. Publishers draft a distribution plan that systematically disadvantages authors without ever proving they belong in the class. Outgoing Judge Alsop, who retired at the end of the last year because he was 80 years old, so may he have the rest of a long, healthy, happy life, but he smelled that the settlement was unfair to authors. When he uncovered the fee-sharing scheme in December 2025, he condemned it, ordered preservation of evidence, and recommended that his successor authorize an independent investigation before approving anything. Counsel's motions for final approval and fees significantly mislead incoming Judge Martinez Alguin as to her predecessor's views by selectively quoting favorable early statements while concealing his recent findings. And she asks that class counsel be temporarily suspended from representing authors pending the outcome of the ethics investigation that Judge Alsop recommended, and authors be provided with court-appointed, uncompromised counsel. Yeah, we want our own lawyers now, Judge. We think these guys are in bed with the Authors Guild because they are representing the Authors Guild in other cases. And whether foreign, unregistered, and/or pre-1970s authors have been unlawfully excluded, and whether publishers are legally entitled to any portion of authors' recovery. Judge Alsop's findings about an undisclosed fee-splitting arrangement between class counsel and publisher attorneys, his concern that the arrangement was concealed from the court and from class members, his concern that the arrangement may have been used to induce settlement terms that disadvantaged authors, and his recommendation that his successor authorize an independent investigation before approving anything. Class counsel's omission of this record is not an oversight. It is an affirmative misrepresentation of the record to mislead the incoming judge. Judge also put his finger on the central problem. And this is what he said in that one meeting, and I'd love to have the transcript from it. Maybe we'll get it eventually. Those older transcripts are starting to come in, so I'll take a look. But he said, "I'm worried that you are working out, behind the scenes, between publishers, some kind of a deal that you want to force down the throat of authors, and say you got to take X%, even though their own agreements give them 100%. So the judge is acknowledging authors are supposed to get 100% of the settlement. I would like for you to explain what is going on between the guilds, the publishers. What kind of deal are you trying to do behind the scenes?" Judge Alsop was correct. Publishers, class counsel, and the Authors Guild, class counsel's client in related litigation, have worked out a deal behind the scenes to let publishers take 50% or more of the $1.5 billion reward, even though copyright law and book contracts entitle authors to 100%. The motion asks the court to overrule objections the public cannot view and which the motion does not fully characterize. The objector's own objection was sealed by the clerk without her request, without a motion, and without a judicial order. So what the hell was going on there? The motion simply did not disclose to the court that the objection raised the issue, as established by Judge Alsop, of suspect coordination between publishers and class counsel to the detriment of the authors class counsel was appointed to represent. Imagine that. You hire a lawyer and you get this big settlement, and then someone else comes in and says, yeah, your lawyers are giving us 50%. What would you do? Wouldn't you go to your lawyers and say, hey, you're supposed to be representing me? How is this representing me if you're going to give half of my settlement money to someone else? But it gets even worse because a claims-made process may deter over 90% of authors from filing. Even if 60% of works have been claimed, it may be the case that 55% were claimed by publishers and only 5% by authors. Amounts not claimed by authors can be collected by publishers. This creates a financial incentive for publishers to place burdens on author claims. The plan improperly establishes a presumption that publishers are entitled to share in authors' recovery. To keep any more than half the legally appropriate award for their book, the author must continue into a new round of post-settlement legal conflict against their own publisher. In that arbitration, the authors will have none of the advantages of class action litigation. Authors' claims against publishers will not be adjudicated by an Article III judge. Class counsel will have washed their hands of the author as a client after requesting $187.5 million in attorney's fees. The publisher will have an attorney, but the author will not. The arbitration will also conceal from the AI industry that they need to negotiate not with publishers, but only with authors. Stepping back to view the forest for the trees, authors deserve to benefit from Anthropic's record $1.5 billion offer to settle infringement claims. The problem is the distribution plan. It is systematically unfair to authors because the publishers designed it that way, and they did so with assistance from class counsel. Exclusion of most authors lets the biggest publishers take more. The claims-made requirement lets the biggest publishers take even more. The arbitration mechanism lets the biggest publishers take even more. So do the other fairness problems identified in the objection. This is not adequate representation. And consider this, the lawyers' fees were like, I think, 12.5% or something. But there's only a few of them, and it's one law firm getting all of that. Then you have the publishers. The publishers represent more than one author, and big publishers represent a lot of authors. So if they get 50% of that, they're raking it in. But all of the rest of that has to be divided among the individual authors. How much of that are they going to get that's left? It's going to be peanuts. It's going to be a pittance. And their own lawyers did it to them. The path to a fair settlement lies in removing the problematic actors from the situation. Authors deserve independent counsel. The court can then resolve whether publishers are actually class members or not. And that's from Leah Bishop, acting pro se. She wasn't doing this with a lawyer or anything because apparently the lawyers have abandoned them. So we at least have a response from one of the publishers. This is from Shahid Mahmood, the CEO of Arc Manor. And he says, I write as a class member to respectfully urge this court to grant final approval of the proposed class action settlement. I submit this statement in response to the objection filed, which characterizes publishers as adversaries of authors who have corrupted the settlement process to divert funds that rightly belong to authors alone. If accepted, this would actually undermine the interests of the very authors Professor Bishop claims to protect. Yeah, do you believe that? Oh yeah, we're doing this for your own good, authors. We're taking half of your money for your own good. Professor Bishop's objection rests on the premise that publishers inserted themselves into this litigation and are attempting to claim money that belongs entirely to authors. This premise fundamentally misunderstands how publishing contracts work, not just at major houses, but at small presses like mine. Yeah, but this isn't a publishing contract, is it? It's litigation. The authors sued, and then after they did the hard work, you guys slipped in and said, yeah, we'll take half of that. Check this out. Publishers acquire exclusive rights and are the legal owners of those rights. Do you think you own your books, authors? What, you think just because you took the time and effort to write the book and poured your heart and soul into your art form, working for years and years and years in some cases to write your novel or whatever it is, you think that means you own it? Nuh-uh, it's ours, not yours. And sadly, that's how the system works. He's not entirely wrong. When a third party infringes the copyright in a work to which the publisher holds exclusive rights, the infringement injures the publisher directly. The publisher is not a bystander to the author's claim. The publisher is a rights holder whose own legally acquired rights have been violated. This is precisely why Judge Alsop's class certification order defined the class to include both beneficial or legal copyright owners. Publishers holding exclusive licenses are the legal owners of the publication rights at issue. The proposed 50-50 split is generous to authors relative to underlying contracts. Yeah, just be grateful we're giving you 50%. You should thank us for allowing you to have 50% of the settlement in this case that you started and that you worked for. And check this out. Under standard publishing contracts, the publisher collects all revenue and pays the author a royalty. For a typical book, that royalty might be 7.5% to 15% of the cover price for print editions. So wait a minute. You're saying when I buy a book, I buy that book for $10, the author gets 75 cents of that? And 25 to 40% for digital editions. Of net receipts, not even the gross. I mean, even if it were the gross, what's their expenses with the digital editions? They've got the initial setup costs, but they don't really do the hosting, do they? Amazon or whoever does that. And it's all the downloading of the books, so you would think, yeah, a portion of that goes to the publishers, but since there's nothing to actually print, the author should get most of that, right? Nope! They don't even get half. 25 to 40%. Pay $10 on a digital download, the author might get $2.50 of it. The proposed distribution plan, which allocates a substantial portion to authors, is therefore more favorable to authors than a strict application of their own contracts would dictate. Professor Bishop quotes Judge Alsop's concern that authors' own agreements give them 100%. With respect, that is not what most publishing agreements provide. They provide for the publisher to collect 100% of earnings and remit royalties, a portion of those amounts collected based on the contractual language, to the author. So this is just like royalties? You just grab any settlement you want and call it royalties? When Anthropic downloaded and pirated copies of books, it did not merely copy the author's words, it copied the finished product that represents the publisher's investment. The harm to the publisher is real, direct, and independent of the harm to the author. Both deserve compensation. Then file your own lawsuit! Seriously, they are settling for pennies on the dollar, like less than 1%, way less than 1% of what they conceivably would have gotten if they had won. Would they have settled for such a low amount if they thought that the publishers could just come in and grab half of it? I hope any reasonable person can see how unfair this is. The proposed settlement represents a historic recovery for authors and publishers whose works were pirated and used without permission. It's the largest copyright settlement in U.S. history, and we want some of that money. Because if we take out our own lawsuit, we might not get as much. Yeah, see, it's all about us. The rights are ours. You get on your knees, authors, and accept the crumbs we allow you to have. See, that's what copyright really does. It sets up publishers as though they were medieval guilds. So just look at the Statute of Anne. That was the first modern copyright law. That's exactly what it did. It set it up so that authors are under the yoke of publishers. Because before then, authors were fine with the arrangements. They'd go to the printers, print their own books, and sell them. The publishers were like, wait a minute, this printing press thing is taking away all our money. We're irrelevant now, so what are we going to do? They ran to the government, got them to pass the Statute of Anne, and that way they were able to keep the authors under their control. The system is not set up to benefit authors or artists. It's set up to benefit the copyright cartel. Authors would be way better off without copyright. This guy has the audacity to say that authors are better off with them. No. Does this sound a bit to you like an abusive spouse? You know, they abuse you and do terrible things to you, but then say, think of how much worse your life would be without me, and convince you that you have to be with them because you couldn't make it without them. That's how I see this relationship between authors and publishers, between recording artists and the record labels, filmmakers and the studios, any of them. That's how the system is. That's what copyright does. That's what it's always been there to do. From the very start, our system was set up in the hopes that it would be better, because we have a First Amendment, because we have fair use, but we've still got this issue that if you want to be an author or a recording artist or something like that, you have to be a servant to the copyright cartel, and they decide how much money you deserve, not your own customers, not the people who appreciate your books or your music or whatever. They decide, you accept their crumbs. That's how it is. Maybe someday it'll change, but until then, I'll still be here pointing it out. And if you like that, then please, comments for the comment god, shares for the share throne, like, subscribe, the bell, and of course, donate.pagosity.tv. Yeah, even I got people who are going to take their cut. You know, you pay me $1 through PayPal, and I'll get, what, 70 cents of that? The more you pay, the less it is percentage-wise. But that's why there's cryptocurrency, because that's an even better deal. You can give any of those ways or become a regular supporter, Patreon, Subscribestar, or Discord. Please check that out. You can get these videos early and ad-free and various other benefits as well. Thank you so very much for watching. Until next time, stay strong and be free.